So without further ado, I'll hand over to Lucy, who will kick off our session this morning. Thanks, Lucy.
Thank you very much. Hi, everyone. I'm just going to, the magic's going to work. Click onto the presentation. So I'm going to talk about exclusion clauses, and it's a very cool area of law. And I'd like to talk to you about it if I could make the slides move. We've got a slight technical hitch. Have I got control of the mouse, guys?
Yes, you've got control, Lucy.
Yeah, it's not working, I'm afraid.
Okay, let me try.
Someone else?
Yeah, I'll do that, Lucy.
Okay, so we've got three main topics: general principles, what happened in Transocean, and then subsequent developments in the law. Can you click on? And another one. Right, so these are the historical general principles regarding exclusion clauses that are not going to come as a surprise to anybody listening to this talk. You start with the general rules of contractual interpretation, and the traditional rule, note traditional, is that exemption clauses must be expressed clearly and without ambiguity, or they risk being ineffective. That's Chitty 33rd edition. Chitty goes on to say the wording of the clause has to be clear and unequivocal. Clauses will be construed narrowly and against the profferends or the drafter. You have to clearly state what losses you're intending to exclude and what contingency is anticipated. And there's also specific rules about things like excluding loss from negligence, known as the Canada Steamship Principles, and a general principle that you start with the presumption that neither party intends to abandon any remedies for breach. You also can't have ambiguity or inconsistency with other contractual clauses. And part of this talk is going to be about how the law has moved on to some degree from some of these principles, including in particular the contract preemptions rule and whether exclusion clauses are in a special category of their own. So can you click on? So we're going to talk specifically a bit about consequential loss exclusion clauses. And so I've done this slide, which again, as I'm quite sure teaching my grandmother to suck eggs, but I always find it useful to go back to the beginning whenever I'm looking at an exclusion clause and just get clear in my head again what a direct loss and an indirect loss actually is. And it obviously comes from the old Hadley and Baxendale case, which defines the limits of remoteness in contract. And of course, Hadley and Baxendale is not about a case about exclusion clauses. It's a case about recovery of damages in contract, which has been used to define what direct loss or indirect loss, indirect loss also being called consequential loss, means. And direct loss is usually regarded as the first limb of Hadley Baxendale, which is losses that arise naturally according to the usual course of things from the breach of contract. And the second limb is losses which are in the reasonable contemplation of the parties because of some specific knowledge that they have about that contract. So that's what people are talking about when they're talking about consequential loss. If you can click on to the next slide. Sorry, back one. Consequential loss has been held to mean indirect or second limb Hadley Baxendale loss over a long chain of cases. So if you click onto the next slide, on this slide I've got on the left hand side I've got the orthodoxy as to the meaning of consequential loss equals indirect loss, and on the right hand side I've got the almost equally long history of people saying it's wrong and the law should be changed. So there's a long chain of Court of Appeal authorities. Some of the, so I've picked out some of the more famous and well-known ones on the left-hand side of the slide. And the comment in Lewison on interpretation of contracts is that it's so well established now that consequential loss is indirect loss, Hadley Baxendale defined, that it may be taken to be settled that at least at the level of the Court of Appeal, similar clauses will be construed in a similar fashion. The protests, on the other hand, on the right-hand side of the slide, have come from the editors of McGregor on damages, who have been saying that it's a false and unrealistic meaning for many, many years. Australia, the courts have said we were wrong, the English authorities are flawed, and in Caledonia North Sea, Lord Hoffman reserved the question whether this construction was the right one. And I'm going to come on to some of the recent cases on consequential loss, which do rather change the picture. Thank you very much. And the next bit is going to be about Transocean. Next slide. Thank you. So the Transocean exclusion clause was a consequential loss exclusion clause, and it had two parts to it, part one and part two. The first part was a general exclusion of any indirect or consequential loss or damages, and the second part had specific categories of loss that were added to the definition in one. And the issue in Transocean was a claim for spread costs, i.e. the costs of maintaining the rig while it was working, and in the Transocean case, while it was in downtime, that was said to have been wasted as a result of Transocean's failures to maintain. And the argument was about whether the spread costs were excluded by the bold highlighted words in the second part of the clause, loss of use, including without limitation, loss of use or the cost of use of property, equipment, materials, etc. And my side, I was acting for Transocean in the case, we argued that the spread costs fell within that exclusion, and Providence were arguing no, it wasn't. So if you click on another slide, we lost at first instance. Popple-Welj said that loss of use was more naturally read as connoting the loss of an expected profit or benefit to be derived from the use of the property or the equipment. And he also said he came to this conclusion because he applied effectively a traditional approach to the construction of the clause. He said the words had to be read narrowly as it was an exclusion clause. He also said it was a defined incursion into a second limb Hadley-Baxendale loss. And he also said, he made this finding on the basis of contention raised by the other side in the second schedule to their closing submissions, that the contract obligations would have no content if we were right as to the meaning of the clause, because Transocean could never be liable in damages for anything if it meant what we said it meant. And that was the point that became known as the Suisse Atlantique point from the Suisse Atlantique case, which says that you don't construe exclusion clauses to deprive all obligations in the contract of any weight or traction. So the case went to the Court of Appeal on the point on the construction of the exclusion clause. And if you can click on one more slide. Can we click on one more? Thank you. Back one. Back a few. Back one. Yeah. And I think back one more as well. Yeah. So in the Court of Appeal, where Moore-Bick LJ gave the leading judgment, it's no coincidence when you read this judgment to remember that the Supreme Court had issued its judgment in the Wood case in 2015. So in between the first instance judgment in Transocean and the Court of Appeal judgment, there was the Wood case came out, which obviously emphasised very heavily that the way to construe contracts was to give the words their natural meaning, and that particularly in commercial contracts, you would expect the parties to be held effectively to the words of the contract that they'd agreed, even if that was a tough bargain. So Moore-Bick had some comments to make on construing exclusion clauses generally, and he said in particular about the Transocean clause, which obviously will be typical of many, many clauses that those listening deal with every day. The clause is to be seen as an integral part of a broader scheme for allocating losses between the parties. It's not, therefore, a simple exclusion clause of a kind which at one time the courts were willing to construe restrictively in order to avoid commercial oppression. And he points out that ever since the decision in photo production, which was back in the 70s, following the passing of the Unfair Contract Terms Act, the courts have recognised that artificial approaches to the construction of commercial contracts are to be avoided in favour of giving the words their natural meaning. He also talks about the meaning of the phrase consequential loss, says it's caused a certain amount of difficulty, and says it's questionable whether some of those cases would be decided in the same way today. But it didn't matter for the purpose of the exclusion clause in Transocean, because the parties were not relying on the first bit of the clause, which had the general exclusion, but the second bit. So he went on to talk about, can we just click on to the next one slide ahead, he went on to talk about the approach to construction more generally. He said you don't invoke the contra preferentum principle. It was an approach where you'd use on the last resort, where the language is genuinely one-sided and genuinely ambiguous. And it's not synonymous with the principle in Gilbert Ash that parties are to be treated as not giving up their rights without clear words. No part to play when the meaning of the words is clear, and doesn't have a role to play in relation to a clause which favours both parties equally. And it was in the Transocean case, as is very, very often the case in oil and gas contracts, it was a mutual exclusion clause and there were cross indemnities. He also talked about Suisse Atlantique and said that the principle should be seen as one of last resort, and only to be applied in the case of doubt as to the meaning of the clause. And it doesn't provide sufficient justification for overriding the party's intention where that has been clearly expressed. So the Court of Appeal had no difficulty in finding that the words in the clause covered the spread costs. So the Transocean was successful in the Court of Appeal. And if you click on what's happened subsequent and one more, what's happened subsequently is I've made a very, very technical and scientific graph to show that the appellate courts have only got more confident in the application of this natural meaning approach in dealing in particular with exclusion clauses. And they've started to move away from applying rules that are specific to exclusion clauses to an approach that says, well, what do the words of this clause actually mean in the factual and contractual context that applies to this clause, not starting from a preconceived 1-0 down sort of starting point when you're looking at exclusion clause. And I've picked out a few of the key cases. I'm not going to talk about all of them, obviously, because I've only got a few minutes left, but just to pick up in the next couple of slides some of the more interesting things that have come out of those clauses. And if you click onto the next slide, on the contra preferentum point, any time that the appellate courts are able to jump up and down on it, they have jumped up and down on it. In impact funding, Lord Hodge said only in a case of real doubt, and not for the purpose of creating a doubt or magnifying an ambiguity. Morbick again in Taberna, saying it used to be a useful tool for the courts before we had UCTA, but the modern view is to recognise that commercial parties can make their own bargain, and the court has to just interpret fairly the words used. Again, restricted to cases of genuine ambiguity. And Jackson, LJ and Persimmon saying in relation to commercial contracts between parties of equal bargaining power, the rule has a very limited role. So the death of the contra preferentum rule, I think. And if you just move on to the next slide, the meaning of consequential loss. I've got a longer version of this talk where I do a slide on the Canada steamship rules, which have also been commented on by the judges in those cases, which also says that you don't really use a specific rule that presumes you can't exclude negligence anymore either. You just again start with the real meaning of the words. But consequential loss exclusions I've focused on for today because they are so common in oil and gas contracts, and because there are two fairly recent cases, Star Polaris and another one called To Entertain Video, where in fact the traditional interpretation of a consequential loss clause hasn't actually been used. So in Star Polaris, Sir Jeremy Cook gave a judgment saying he applied the, I think now well established point that you don't use the contra preferentum rule unless you have ambiguity, and so he didn't need to in the case. He undertook a detailed analysis of the scheme of the contract as compared with the individual words in the relevant clause, and he looked at the long line of authorities on the meaning of consequential loss. He nevertheless held that in the context of the case, on the facts and on the specific words of the contract, that consequential loss in the Star Polaris contract meant financial losses consequent on specific defects that were the only grounds of liability for the builder under the shipbuilding contract. And I've put the clause not the whole of clause 4 because it was quite long, but the main bits of clause 4 on the left hand side of the slide, and you'll see that the way the contract worked in Star Polaris was that effectively there was a general exclusion of for the benefit of the builder, and the only exemption from that was for certain specified defects that the builder was going to be liable for. But on the other hand, the wording of the clause, when you just read it, no liability or responsibility whatsoever or howsoever arising, blah, 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 for any consequential or special losses, damages or expenses unless otherwise stated herein, looks like quite a familiar form of wording for a consequential loss exclusion. So this is a fairly, the wording of the consequential loss bit of the clause is a fairly standard piece of wording, and the High Court felt able to depart from the established meaning of consequential loss without really any difficulty. And there was no appeal from Star Polaris. And if you just click on to the next slide, Mrs. Justice O'Farrell in the TCC has just a couple of months ago issued her judgment in the case called To Entertain Video and Sony. And that was a logistics contract which had a general exclusion clause in relation to any indirect or consequential losses in a very familiar format. And she also repeats that normal contractual principles apply in construing the clause, and she does it, for what it's worth, she does a 1-paragraph summary of the effect of the various Supreme Court decisions like Rainey Sky and Arnold and Wood and so on, in 1 paragraph, which is quite helpful. She also then helpfully reviews all the authorities on consequential loss exclusion clauses, running through from paragraphs 225 to 232. So it's a really convenient starting point if you're having to look at this issue for any clients. And then she says, any general understanding of the meaning of indirect or consequential loss must not override the true construction of the clause when read in context against the other provisions of the contract and the factual matrix. She actually finds that the consequential loss has its usual meaning, but it's absolutely clear from her judgment that she wouldn't have felt constrained to hold that it had that meaning if she thought that the words of the contract and the facts indicated the contrary. So I think what we're seeing now is a quite interesting situation where the High Court is actually moving the law on in relation to the meaning of consequential loss, with no appeals so far against those 2 decisions. So Lewison appears to be, I hesitate to say it, but wrong in the interpretation of contracts when he says that it's going to need Court of Appeal intervention. It looks to me as though the High Court is taking the approach of giving the natural meaning to the exclusion clauses, and that means also reading consequential loss naturally in the context of the words that stand in the clause. So that's, I think that's the last slide. Yeah, so that's it from me for now. I will obviously be doing a Q&A later, and I'm just going to hand over to the HKA team. They're just going to change the slide deck.
Okay, hi, good morning everybody. Thanks, Lucy. It's Damian Waters here from HKA. Hopefully I'll have better chances and better opportunities to work the slides correctly, so I'll give it a go now and see if that works. Yes, we seem to be working okay. This morning I'm going to just briefly talk about logic contracts, which are oil and gas contracts specifically used in the North Sea. And the logic contracts first sort of came out in 1997 as crime contracts. Crime was an acronym, Cost Reduction Initiative for the New Era, and that was founded in 1992 as a cost reduction initiative. So it wasn't about contracts at all. It was about how we can actually reduce costs in a very competitive market when, as we all know, extracting gas from the UK oil fields is very expensive compared to other parts of the world. And as part of that cost initiative, they developed model contract forms for use throughout the industry. And we then moved on to Logic, which was another cost initiative that was developed by the UK Oil and Gas Industry Task Force, and that became operational in 2000. And again, that wasn't about contracts or contract law, it was about competitiveness in the industry. Anyway, Crime became a subsidiary of Logic, and now all the standard forms are published and updated as Logic contracts. And if you Google Logic, you'll find your way to the website, and there are several forms of contract in the suite of Logic contracts, and several editions of each form are available to purchase. On the next slide here, I've got some examples of the Logic contracts that are available to purchase. And actually, there's a lot more than that in reality. I couldn't get any more on the slide, but they, as you can see there, what I do like about Logic is that they do try and cover for every eventuality in terms of the type of work that you're undertaking, whether it's SME, whether it's offshore or onshore, whether it's specific to rigs and well services or decommissioning, or even subcontract. I've highlighted there the construction edition, the November 2018, which relates to fabrication works, topside installations and hookups. The reason I've done that is because I want to go through a particular subclause of that contract when it comes to claims for damages, and in particular prolongation costs. So yes, we'll just have a look now at clause 13, variations of the construction edition, and you might wonder why I'm referring to a variation clause when I'm talking about claims. Well, all will be revealed on that one. And what I mean by that is, if you're, say, for example, working in the Middle East on oil and gas contracts, then most of your contracts are bespoke, but loosely based on FIDIC, particularly the FIDIC Silverbook. And what you would have in FIDIC normally, obviously, is a variations clause and a claims clause under clause 20.1 through the notification of claims. But you don't have that in Logic. There are no separate claims clauses in Logic contracts at all. All claims for extension of time and additional costs are addressed as a variation. And we know that almost immediately from the definition of variation, as it means both an instruction to the contractor, but also an adjustment to the schedule of key dates, in effect an extension of time, and or a contract price adjustment to which the contract is entitled to under any clause of this section of the contract. And then when you read the variation clause itself, clause 13.2b also states that the contract price and the schedule of key dates shall be subject to adjustment only as a result of a variation, which is quite interesting and quite unusual. The variation clause in Logic is quite complex, and there's quite a lot to talk about in there that I don't have time to go through with you this morning. So we obviously know that variations that could result in claims for loss and expense may arise through instructions from the company, but there are other possibilities. And within the variation clause, we have subclause 13.6, variations in respect to matters of delay and or additional cost. And we have three different possibilities to claim as the contractor. These are all paraphrased from the clause, but the first one is failure by the company to provide drawings and specifications and or other information in accordance with the contract. So that could be delay in provision of information, which then could cause critical delay and additional costs could be incurred. The second one would be failure by the company to provide materials, services and facilities in accordance with the contract. That could be free issue materials, for example, or other provisional services. And the third one is the provision of incorrect information by the company, which it is liable under the contract. Obviously, it's a model form, and therefore it's subject to a lot of bespoke amendments. And as we quite commonly see, it's often the case for the company to, in effect, say, well, yes, we'll provide information to you, but we are not liable for it. The contractor has to make his own investigations, etc. So obviously those potential opportunities to claim have to be obviously considered in conjunction with the specific bespoke amendments to the model forms. So if, for example, we have a variation in effect a claim, and that causes delay to the critical path and delays are incurred, then normally you would be entitled to prolongation costs in those circumstances. And the logic contracts provide two possibilities to claim, or two options really for the parties to consider prior to entering into contract. The first is the normal approach, you would say, actual costs incurred. And the second is pre-agreed rates and prices. And that's often quite common in oil and gas projects, although both have their pros and cons, and both result in, unfortunately, in disputes in the industry, once issues arise. So in the contract, it provides a definition of actual cost that the contractor is entitled to cover, and what that means is necessary direct additional cost. Obviously, Lucy talked before about the distinction between direct costs and indirect costs, and here we're talking about direct costs. But it does expressly make clear that this does include additional overheads, so that would be site overheads and off-site head office overheads as well, but not profit. On the other hand, the contract provides for the parties to pre-agree rates and prices. And what it states in the contract is, in the event that specific rates and prices for delay and or extension are included in section 3 of the contract, which is a remuneration section, then those rates and prices shall be used where appropriate to evaluate any adjustment to the contract price. So then we'll get into a debate possibly between the parties about where it is appropriate to use those rates and where it isn't. And also the way in which that schedule is drafted will obviously depend upon how the parties can then utilize that document for assessing prolongation costs after the event. An important point there is on the last sort of part of the clause, and it says there that it shall be deemed to represent direct additional costs to the contractor as defined herein. So what that means is that if you do pre-agree rates and prices, then those rates and prices need to include all the overhead you would otherwise claim through an actual cost claim. So that would include prolongation costs, site establishment costs, and head office overhead as well. So that's an important point to remember. Seem to have lost control of the slides. Here we go. So what are the pros and cons of the two possible methodologies? Well, if you think about an actual cost perspective, from an actual cost approach, the contractor should, in theory, recover the costs it has incurred and therefore be put back in the position it would have been in had the variation not occurred. Obviously, I say in theory because there could be lots of arguments, and there are lots of arguments about disallowed costs and whether costs actually genuinely flow from the breach itself. And, obviously, I work as a quantum expert. I know the cost and time spent in proving actual cost claims, and they can be huge, particularly on large EPC oil and gas contracts. And the costs that are spent with consultants, quantum experts, lawyers, etc., is enormous and very time consuming. So I may be putting myself out of business by advocating the pre-agreed rates and prices approach. We also have confidentiality issues when it comes to actual cost, and parties are often reluctant to provide the level of detail that is necessary for arbitration, for example, in terms of proof of cost. And the last point there, I think, is also important to remember, particularly in relation to marine vessels, because often these vessels they're not new, they can be 20, 30, 40 years old. And therefore, if you're valuing the works on a cost basis, then really that vessel is depreciating in value, and really all you're entitled to is the running costs of that vessel. Yet the value of that vessel to the company is enormous, and it would usually be utilised throughout the world year round. And a delay to a project, which in effect means that the vessel cannot move elsewhere, causes a huge detrimental loss to the company. And therefore, really, from a marine spread perspective, it's always preferable to go down the pre-agreed rates and prices approach. The pros of that approach obviously would be the price certainty, but again, in theory, it depends upon the quality of the schedule that you actually produce and incorporate into the contract. And there's nervousness actually from employers to agree to rates and prices, because they often think that the contractor is going to make a profit on the pre-agreed rates and prices. But when you think about the actual costs that are spent in trying to prove actual costs further down the line, and there are benefits, significant benefits, to agreeing pre-agreed rates and prices, provided that the parties actually take the time and effort to properly consider what is likely to happen, how delays may arise, which plant, equipment, materials, staff, etc. are likely to be affected by that delay. Because from my experience, I often find that price schedules are poorly drafted, and therefore we then get into arguments about, is it appropriate to value the cost of the delay event based on the rates and prices agreed? Do we have to revert to an actual cost approach? And some of the problems that arise include composite rates or lump sums, which then don't really allow you to use them correctly, and a pro rata approach may not be appropriate. We also have post-contract changes in method, in work sequence, in types of plant and equipment that are deployed, which are just not picked up in the agreed schedule. And therefore that results in problems and disputes when the pre-agreed rates and prices was intended to avoid such disputes. So, from a quantum perspective, if we are looking at actual cost methodology, I think it's always best to go back to fundamentals, not only in terms of carefully reviewing the contract conditions, but also the fundamentals of what you're trying to prove or disprove. And I've got there sort of 6 sort of high level issues that will be pretty familiar to everybody on the webinar today. But I think it's just worth always keeping these things in mind. And when it comes to costs claimed, they've got to be due to the delay event itself and not due to other reasons. And that is often a problem where costs will be incurred in any event, and the contractor adopts a kitchen sink approach, claims everything without actually trying to properly establish the causation to the cost itself. The cost claimed should also be claimed in the time periods when the delay event was felt, and therefore the link between delay analysis and quantum is absolutely crucial, and there needs to be full alignment between quantum and delay and technical to get that right. Obviously concurrent delay is a topic of itself, so I don't want to go into that one. I would also point out the problems with the project cost ledgers as evidence, because again, contractors unfortunately do adopt that kitchen sink type approach and say, well, if it's on the cost ledger, it's claimable. But we obviously have to bear in mind that those costs must be reasonably incurred and linked to the delay event itself. Right, and just because you've incurred the cost or are likely to incur the cost, does that mean that you're entitled to claim it? Not necessarily. Another issue is tender allowances. Again, if you talk about the actual cost approach, they're not particularly relevant to the cost claimed at all. However, they may be highly relevant to claims for premiums thickening, for example, and the resources and the resource program could be highly relevant in that regard and would need to be reviewed. So that there are some of the fundamentals there that I think it's important to bear in mind. So, in my experience, you know, parties don't get it right at contract stage. They approach pre-agreed rates incorrectly. They look at remuneration without the benefit of hindsight, but without really giving proper consideration to those issues. And then we're left in a situation where the parties try to renegotiate the contract. And in oil and gas, that often takes the form of a memorandum of understanding, or more commonly known in the industry as a memorandum of misunderstanding. But that's the way things go. And there's a case there, HSM Offshore BV versus ACA, which is a TCC call, which Coulson decided in 2017. Now, that case is predominantly about liquidated damages and estoppel, but it was a logic subcontract. And in the judgment, it was quite, when you read the full judgment, it is quite interesting because the parties were completely misaligned as to what had been agreed in the memorandum of understanding. And one party thought that the lump sum contract was in the bin, basically, and it was a fully renegotiated cost plus contract. And Coulson did not agree with that approach. And it's just really an example of how, if you get the contract right and you take the effort up front to do your due diligence and to provide a proper pre-agreed schedule of rates, which takes into account the likely issues that would arise on the project, there may be, in certain instances, the memorandum of understanding could be avoided. And also, unfortunately, again, parties do not take the time and do not really engage with their lawyers correctly when drafting the memorandums of understanding. So that then results in more ambiguity and more inconsistencies than under the contract itself. So they're just a few of my thoughts for today. So thank you very much for your time, and I will now hand over to Colin. Thank you.
Thanks, Damian. Okay, so you've got through the exclusion clauses, weaving through the minefield that Lucy has described, where you think you're resolved there, and so you just hand it over to the damages expert to actually produce a number for you. But actually, it's not necessarily the end of a lawyer's involvement in terms of how the case is developed from a damages point of view, because the points I'm going to highlight here are in many cases issues that the legal team will need to decide on from a tactical point of view. So let me move through some of those. What we're looking at here is actually whose loss are we calculating? What is that loss? When is that loss related to? Where does the dispute relate to? And how do you actually value it? Obviously, I'll move quickly because we're short of time. But in terms of who, if I say, when we're identifying who's lost, has that loss been passed through to others by the claimant? So I had one case which was a government claiming against a contractor for additional costs in relation to a project. But in reality, that project was actually being funded by the European Union, so the country was suffering no loss. Should other parties be included in the claim? Again, another case that I've been involved with, a group of companies, some of the profit is actually taken in one company, some of the profit is actually taken in other companies. Only one company is actually being named as the claimant. And I think that money is potentially being left on the table from that point of view. Another different party bringing the claim, again, actually, particularly sometimes if you've got joint venture agreements and shareholders, you need to make sure you've got the right people actually at the table in terms of who's actually on the claim. And equally, if you're respondent, look carefully in terms of whether the true losses are actually with the people that the claim is said to be in the name of. So what is the loss? Well, you can actually phrase it in different ways. It can be a loss of revenue, it can be the loss of value. If you're talking something like expropriation or contractual action that made the whole loss of a company happen, then it could be valuing the whole company, valuing a project. And the reason I put all the different ones up is because, again, it can make a difference in terms of approach, in terms of timing. So it's just worth having that discussion early on in terms of how the different elements fit together. in many of these, you end up looking at a but-for scenario when you're looking at the loss, and when you're talking about what the loss was, the but-for scenario is what would have happened had that alleged breach not occurred. So that obviously depends a lot on the underlying assumptions. It also depends on the company's own forecasts, how robust they tend to have been, what context they were prepared in, and then really testing the reliability of that information. Then you move on to when. So in terms of the actual date, this is something that the legal team can be heavily involved in from a factual point of view. Is it one single date? There was one breach of the contract, or there was one act of expropriation if it's an investment treaty case, or actually was it multiple acts and there's therefore a potential choice of different dates to make the claim on? Well, that date can make a big difference, particularly if you're looking at a valuation. And if I take an example of an oil and gas company valuations do vary depending on the expectations of oil prices, and the expectations of oil prices have varied significantly as the oil prices themselves have varied, which is what this graph shows. So as you see the big price drops from 2014 to 2016, and again because of the COVID crisis more recently, if a claim is set just before those rather than during or at the sort of trough of the pricing expectations, that will make a big difference to the forward expectations of value for that company. So well worth thinking about. And then the other point is actually, if you're looking at a claim that is for a set period, is that period appropriate? And when you're looking at the physical life, let's say of a factory, of a ship, of a reservoir, on the UCOS case, the ECHR case for UCOS that I acted on, the claimants put in a claim for 80 further years of uninterrupted revenues from the reservoirs. And was that really realistic? Equally, obviously, in a number of different projects, the contract life is what's going to determine how long a set of damages can actually be claimed for. Because if the contract was due to finish in 2 years, you can't be claiming necessarily for 20. And then the other two, in terms of when looking at how long the claim is for, whether the market would be available for the whole of that period, would there still be the market for those particular goods? And whether mitigation longer term should take different forms. So once you've dealt with the when, you then come to the where. And obviously, country risk is a significant element in many of the cases that we look at around the world. Risks are not the same in every country. Risks are not the same in every currency. So actually looking at where the project is and where the cash flows are, where those actually, what currency those are being paid in, needs careful consideration. And it's not as simple as this is a project in country X, and therefore we must apply that country's discount rate. Because actually, I've worked on an airport case where the country happened to be in Asia, but the revenues were actually coming from international tourists from all sorts of different countries, and everything was essentially dollar paid. So there was relatively little reliance on the local economy in terms of what country risk the project was exposed to. The other element in terms of where a project is also, again, looking at the local market availability, what the transport and logistics are. I had a case recently looking at a mining project, and part of the element was, okay, if you have a mine in this location, how do you actually get the metal or the mining ore? How do you actually get that to market? In different countries, finance is an issue. I've had cases turn completely on what finance was actually available in a particular country. And finally, geology. If you look at oil and gas type projects, sometimes discussion about what could be expected in a particular place can be coloured by what was actually achieved in terms of reserves or in terms of production in neighbouring sites, and the extent to which those can be brought across. Now, those are obviously technical discussions, but with a major impact on the quantum. And so when we're looking at damages, we would work with a technical expert in those areas. So the how is, if you look at the two main areas, if you're looking at valuation, are income approach and market approach. I'm not going into the details of those today in terms of how they do them. That's a separate talk. Here is just making people aware that, okay, that's one of those is the normal one, but there are alternative approaches, and the significant discussion in terms of which of these is appropriate. Happens quite a lot if you get into earlier stage oil and gas and mining projects, and the question is, what stage should you be using an exploration valuation? At what stage should it be sunk cost? So those are different analyses that need to be considered. And again, the legal team can have a significant input in terms of discussing what might be appropriate with the expert on those. So let me just move finally very quickly to a couple of case studies. First one was an oil rig contract termination. Now, it was allegedly as a result of technical defects. It also happened to be after the time of the last price crash. So the respondent's case was that this was actually just termination for convenience following that downturn. Key issue, therefore, was obviously the state of the market at that time. So timing was critical as to when the actual termination was said to be, and debate was on that, as well as what the true costs of operation were. What were the actual physical costs of operation with and without certain defects that were stated for the rig, but then also who actually bore those costs, because that obviously made a significant difference in terms of the damages. Second case study was an investment treaty case claiming against the government for the value of a gas concession that was alleged to have been expropriated. Here, the key issue around the location was that there was no gas market in this country, and that actually getting the gas out to a marketplace not only required drilling in a terrorist-held area, it also required a long pipeline through mountainous and terrorist-held areas to another country which was not seen as a politically safe country to set up an LNG plant. And those sort of factors had not been considered by the claimants. And also it was a question of who the party was in that case, how they were actually valuing the investment for that particular party that was involved. And then the final one, if you're looking at expropriation, because this brings up damages values issues again, it's all very well projecting a long cash flow, but if a company is actually not expected to be solvent over the next 2 years, then it may never reach that longer term cash flow. And that's very relevant when we're looking at the current situation where there's predictions of over 200 oil and gas companies, for example, going bankrupt within the next 18 months. So that is a key issue. Now, I'm conscious we need to leave a little bit of time for any questions. So at that, I will stop and just raise all the questions people wanted to ask at this stage. Lucy, did you have comments? If we don't have questions right now, were there particular comments you wanted to throw in?
I mean, I suppose the kind of theme of your your comments about damages and Damian's is probably the need to be precise about what it is you're claiming, so that you can fit that back into the contractual regime, but also make sure you collect the right information and you can prove it. That seems to me to be the sort of underlying, the sort of thread that binds those two presentations together, which of course I totally agree with. You have to get clarity at the beginning.
No, absolutely true. So, and it is dangerous if you go part way through a case and then you find out that it should potentially have been structured a different way. So,
yeah.
so that's why I throw up these questions early on for people to make sure that they're actually addressing them in their cases. Damian, anything else from you? No, sorry, go on.
No, go on, Damian.
No, I think that's right. I mean, that's the thread through the three, obviously three slightly different topics we covered, but that would be the thread through them, of course, in terms of giving proper consideration at an early stage to the right legal team and the right quantum and the right damages team. So some of these issues are picked up early enough. It is quite common for cases to sort of fundamentally change at quite a late stage, and we need to try and avoid that if we can.
Yeah, there is a question, but nobody's brave enough to do law ones. The question is, can we get slides? The answer is yes, we'll circulate the slides. And actually, no, there is. I tell a lie, there is a law one. Can I envisage a case where all liability is absolutely clearly excluded and the contract is essentially toothless as a result? Well, that basically is the Swiss Atlantique case, and it's always. Sometimes I find myself going back to the cases that you effectively last heard of in law school, and then when you read them again, you realise why they are the classic cases that are taught. Because when you're a practitioner, you appreciate that having that kind of extreme example to test against the law is really, really useful. So I can envisage the case. I think when we were arguing the Swiss Atlantique point at first instance in Transocean, we managed to find sort of one or two very, very small liabilities that weren't excluded by the various cross indemnities and exclusion clauses, but we couldn't find very much. But that we said to the judge at first instance, not very surprising. This is a sophisticated, complete code oil and gas case with a set of cross indemnities that are designed to mean that the parties know they know exactly where they are. So I think it's not on the facts of Transocean in terms of what was and wasn't excluded. It's not too surprising to me that Moore-Bick ended up saying in the Court of Appeal that Swiss Atlantique didn't really have any relevance, because in a tightly drafted commercial contract, people do get pretty close to allocating risk for most things that can happen, and it's not very surprising that that's what they want to do. I think the answer to the question is you can imagine the situation, but the Moore-Bick judgment in the Court of Appeal is a really strong indication that that the courts don't really like the Swiss Atlantique point much anymore. And you have to bear in mind that, I mean, I did a sort of short version of the talk, but you will have noticed that in the comments that the judges make, they talk about a change in approach since UCTA was passed in the UK, where prior to UCTA, there was a certain amount of people doing judicial handstands and gymnastics to try and protect parties from a really onerous exclusion clause. And they all keep saying, we don't have to do it that way anymore because people that need protecting have been protected. And after that, the big boys are just arranging who's going to pay who and in what circumstances between themselves. So it comes down to the clarity of the word.
Do you think, Lucy, the trend's a good one in terms of this trend towards natural meaning and and avoiding sort of common sense, like commercial common sense arguments, I suppose, in a certain way, to say, well,
commercial common sense is still very much live. It's absolutely still live. I think Wood made absolutely clear in 2015 that you're looking at a combination of what do the words say, and natural meaning means the natural meaning in the commercial context and the factual context. So all of those points are still live. I mean, I'm not in favour of a purely kind of black letter approach where you just look at the words and don't try and make them make sense. But I think the Supreme Court have got to the position where they're effectively saying you should try and construe the contract so it makes sense. If the words are particularly clear, then you will implement whatever they say. There's a few more coming up.
If I pick the next one that was there in terms of differences in approach to claim depending on region, there is a difference to the approach, not just on region, but on country and actually on exactly what the project is. If I give an example of somebody trying to argue what the value of a gas concession was in one landlocked African country, by picking 5 projects, most of which were oil rather than gas, in completely separate countries, most of which weren't landlocked, you can't value the claim in the same way in the different countries there. So definitely you need to look at your location carefully. Lucy, I think the next one is probably more for you in terms of.
Yeah, I was just going to add to your comment on that. I mean, obviously I'm a disputes lawyer, and from my point of view, the different approaches tend to be whether you're in international arbitration or in litigation. And for sure, there's a different approach to international arbitration, and it's highly, highly relevant if your contract's got an arbitration clause. Obviously, the law of the contract will influence your choice of arbitrators to some degree, and civil code arbitrators, irrespective really of what the law of the contract is, have a different approach to common lawyers. And so I certainly present the case differently depending on my tribunal. That's the big difference on the way I do it. And what's the next one?
Dealing with variation claims met with an argument that the consequential loss exclusion does not allow the claim.
I haven't seen that, but I'm trying to think how that would work, because the spread cost is something that the employer side incurs, and that would be the side giving the variation instruction to the contractor. So I suppose you could have delays caused. Yeah, I guess I can see that, but then you'd be saying that the employer is making a claim against the contractor for a variation that the employer's instructed. Well, that doesn't sound possible. If the question generally is that there was a variation and for some reason there was a spread cost consequence of the variation, whether it was excluded by the exclusion clause, I mean, that would obviously be surprising. The idea that costs incurred as a result of variation were excluded, you'd have to go and look at the contract and see if the exclusion clause was wide enough to cover costs incurred as a result of the variation. But if the contract says that if you have a variation instructed and that causes cost, that you can recover it, it's unlikely to be construed that the exclusion clause bites on it. But it would depend on the words.
Yeah, it's this point on the logic contracts as well, Lucy, maybe misinterpretation of the meaning of direct and indirect, because that clause is a variation, encompasses all claims, and it talks about only direct costs are recoverable.
Yeah, there's a limit on what you can recover under the variation clause.
So yeah, what's direct, what's indirect, that kind of thing. But I think it's wide enough. But,
Yeah, well, I mean, most kinds of costs that are normally incurred are in fact direct costs.
Yes,
it's why exclusion clauses always go further than just saying indirect costs are excluded and add a whole load of other categories, because otherwise you wouldn't be excluding that much.
Absolutely.
Damian, there was a query about the actual cost methodology, and if you could explain a bit more on tender allowances to the costs claimed.
Well, yeah, it was just a point that a lot of the time, sometimes you see where contractors go back to their tender rates and use that as the basis of claim. And what I'm saying is that in most contracts, that's not the right approach unless you do have this specific agreement, pre-agreed rates. And again, you do see where parties don't draft that correctly in the contract, and therefore it's not entirely clear that the pre-agreed rates are always applicable in that particular case. But if you don't have that pre-agreement, then most contracts, FIDIC, logic, etc., you're reverting back to actual cost, and therefore at that point, you've got to prove, or you've got to prove all costs, to the level of detail to satisfy an arbitral panel or a court, and that's quite onerous in reality.
Gotcha. Okay. We will run on for a few more minutes, perhaps just to answer at least a couple more questions. But obviously, if people need to drop off because we've hit the hour, do feel free to do so. But Lucy, there was a question for you on elaborating on the iterative process approach to interpretation.
Yeah. So it can be quite hard to find your path through the Supreme Court cases because they came thick and fast a few years ago. But I actually think it's not all that. I don't think it's all that complicated, really. What the Supreme Court basically says is there are two ways of looking at a contract. You can look at just the words, or you can look at the factual matrix effectively. And they call it textualism, the black letter approach, and contextualism is the factual matrix commercial sense type aspect. And they basically say it doesn't really matter which one you start with, as long as you test the contract, your case on what the contract means against both. So they are effectively saying that whatever you're saying the particular words or the clause means has to make sense, both as a matter of the words of that clause and the contract as a whole, and also as a matter of the factual background and the commercial common sense. And they say in terms that they will strive to, if the words are not particularly clear, or if they're capable of two meanings, they will choose the one that gives the commercial common sense meaning, as opposed to the one that doesn't. And they also make another point, which I think is actually quite a helpful guide when you're in practice trying to apply the law to your contracts. They say that the worse the drafting is, the more they will tend to the commercial common sense, using the factual matrix to understand what must have been intended. The clearer the drafting is, the less they're going to need external factors to understand what the parties meant. So there's a kind of, I think of it like a seesaw, with the better the drafting, the less the facts, the worse the drafting, the more the facts. So it's iterative in the sense that you check your meaning against both tests, but you don't have to go around in circles. I think that's what they were trying to avoid.
There is a related, well, I think maybe related question in the sense of somebody asking how robust do you think LDs will be as the sole remedy for all and any delay, that type of wording.
Yeah, that's pretty robust. There's quite a lot of authority on that type of wording. You have to obviously look at, I mean, that's the example given for all and any delay is very broad wording. So that would, somebody's trying to do a sort of catch-all and say, okay, any delay, it's LDs, that's it. You have to look at the wording itself to see how broad the LD's remedy is meant to be. Is it catching everything, or is it only for one specific type of loss? So you have to look at the words. I know this is what lawyers always say. But yeah, it works. It works in principle, for sure.
Okay, cool. Damian, there's one for you more, I think, which is if you're looking at quantum assessment for prolongation, you've talked about pre-agreed rates versus actual costs, but if it's longer prolongation claims, in practice, would that ever be based on variation rates? Spread rates are generally very high, so it wouldn't suit the client, and variation rates are often rushed, and also wouldn't generally consider any third-party costs, direct or indirect.
Well, that's true, but I mean that's the point I was making, really, that it's really good for parties to stress test their contracts and war game these things before they actually sign up, because that's the problem. They go into contract with a set of rates. Say if they go down the pre-agreed rates approach, but they don't properly consider what might happen, and then we get into arguments about is it reasonable to use those rates or not. The contractor may not want to revert to cost, but he may well be forced to. But you're right. I mean, there's no reason, particularly at the moment with low inflation rates, that parties can't, even on projects of 3 or 4 years long, there's no reason why they can't actually pre-agreed rates, you know, for those kind of durations. In the past, in at times of high inflation, then yeah, or even in certain parts of the world, maybe it wouldn't be appropriate to fix rates for longer than a couple of years. But you know, again, it would very much be geographic specific and you know, market specific as well.
Yeah, I guess that could be interesting post-COVID to actually think whether rates will be the same as what they were before.
Yeah, absolutely.
In various ways. Okay. There's a question about the in construction. We have the Society of Construction Law Protocol on delay and disruption. Have we got similar for oil and gas? I think
We do, but I'm not sure that means we're missing anything too much.
No.
I never like criticising the SCL protocol because it's such a valiant effort to give some guidance on something that's difficult and complicated. But I think sometimes it's possible to rely too much on the SCL protocol and not enough on the contract. And people can get, sometimes in UK construction, certainly people get a bit led down a path that isn't necessarily the right one. It's better to just look at your contract.
Okay. If we take maybe two more and then wrap up for quarter two. Lucy, was the additional wording inserted in the Transocean / Providence con loss clause really necessary to exclude the spread costs, or would loss of use potentially cover this?
Well, we argued that. We said loss of use was enough, and the reference to cost of use put it beyond any doubt. And in the Court of Appeal, from memory, I think he says he doesn't have to come to a decision on it, but I think he says he's inclined to think loss of use might have been enough on its own, but he doesn't go so far as to say it definitely would. I think he says that cost of use puts it beyond doubt. But go and have a look in the Court of Appeal judgment's really short in Transocean. Go and have a look at his judgment and you'll find there's a bit on it about how far you can go with loss of use, because obviously that's what you normally see, isn't it? You just see loss of use and not necessarily all the extra bits of words. And so it would have been actually quite helpful if the Court of Appeal had done a whole bit on what loss of use on its own covers, but they didn't go that far.
Okay, very helpful, thank you. And Damian, one final one. Are you seeing logic used a lot for renewables and cables, i.e. non-oil and gas?
Not too much. Occasionally, but on the renewables side, I'm seeing more in the UK anyway. I'm seeing in Ireland, I'm seeing more NEC and some FIDIC. So it's not as widely used as those, but you do see it on occasion. Yes, I've seen it, but it's, you know, it's not as common as NEC and FIDIC for renewables. Okay,
great, thank you. Right, we better wrap up there. Thank you both. Thank you to Suzanne and Sheila for organising, and thank you to all the attendees for sticking with us and asking the questions at the end. Thank you.
Thank you.